Hi, Tim Blankenship here with Divorce661.com, and I just got a great email question posed to me that I thought would make for a good podcast. You know, I have probably over 1,000 videos and several hundred podcasts and 1,500 blog posts. I try and answer every question I get on one of those mediums, and this question was very interesting, and I don't think I had answered it before. So here it goes. The question was that a party appeared at a prove-up hearing. So what this was is this was a default case, most likely, and the court called the parties in, or the party in, the petitioner in, to ask some questions, and usually they'll ask for you to set a what's called a prove-up hearing for issues of community property, and this is what this was surrounding. But in this particular case, what happened was at the prove-up, the court agreed to give the petitioner two pieces of community property, and then said the judgment would be submitted and she'd get copies. Well, it turns out that when the judgment was received, it appears that the jurisdiction was reserved over the issue of these two pieces of community property. So one of two things happened. Either the judge made the decision to award the community property to the petitioner and then forgot, and when they went to write up the judgment, whether it be the judge or the clerk, they put that it's reserved, or the judge simply changed his or her mind and left it to be reserved. And what that means is that these issues of community property have not been resolved, and it's still under the court's purview to make a decision on what to do with that. So what I would recommend this person do is get a copy of the court transcript from the hearing. And what you'll have to do is you can call the clerk or go to the clerk in the department, ask them for the name of the transcriptionist, and they'll give you the direct number because they're all independent contractors, and you'll need to order a copy of the transcript. You could start first by trying to get a copy of the minute order. The minute order is the clerk that sits next to the judge, who takes notes essentially. So it's not a transcript of word for word. It's more of the highlights. So before you pay for a transcription, a certified transcript, maybe start with the minute order, and you can just ask the clerk in the courtroom for the minute order for that particular hearing date and see if it's on there where the court or the judge is saying that you can keep that community property. If that doesn't handle it, then ask to get a transcript of it so you can see the actual words as they're spoken from the judge, where they told you you're being awarded that property. So I hope that helps. Tim Blankenship, Divorce661.com. It's a great question. And if you need help, please give us a call, 661-281-0266. We'll talk to you soon.